We begin from the nation's capital, where the Supreme Court has dismissed a suit filed by the People's Democratic Party challenging the eligibility of the Vice President-elect, KashimShettima, to contest the presidential election that was held on the 25th of February. The court held that the appellant failed to show documentary evidence that Mr. Shettima was a candidate for double nomination. Judiciary correspondent Shettima reports.
The People's Democratic Party contended that the manner the APC and Asiwaju Tinubu nominated Mr. Shettima as vice presidential candidate for the election was in gross breach of the provisions of the Electoral Act. The party had argued that there were evidence to establish that Mr. Shettima was nominated twice, both for the vice presidential position as well as for the Borno Central senatorial seats, an action the PDP maintained was in contravention of the law. Delivering judgment, the Apex Court held that the issue of locus is important. A plaintiff's locus is linked with the court's jurisdiction. A plaintiff must show harm or substantial harm done to him by the action he is complaining about. The appellant relied greatly on Section 245, subsection 14c of the Constitution. This section deprived the appellants of the locus as it bars interference of political parties into the affairs of other political parties. There are exhibits before the court that the fourth respondent withdrew his nomination or candidature for the Senate before accepting the nomination for the Vice President. The fourth respondent did the needful before accepting the nomination of the Vice President in line with Section 31 of the Electoral Act. The determination of pre-election matter has time limits, the 18 days for the trial court to exercise its jurisdiction and the 16 days for the appellate court to exercise its jurisdiction has lapsed. The suit was a waste of judicious time of the court. A cost of 2 million naira was awarded against the plaintiff.
Irrespective of the unlawfulness of what APC did, we are not members of APC and we cannot challenge it. Well, this is the Supreme Court. We can't, like I told them in court, we can't appeal to God. We will stop here. We are bound by their judgment.
The Supreme Court has spoken and spoken very, very loudly. And I think the significance of it is not so much for the judgment, which we ordinarily expected, considering that we believed from day one that this was a frivolous suit. And we have canvassed that in the High Court, in the Court of Appeal, and the Supreme Court has affirmed that we are right.
The court took her time to explain duties in the judgment by citing an example of 1999 where Atiku Abubakar won the governorship election in Adamawa State but also got nominated as the vice presidential candidate of the PDP to run alongside Olusegun Obasanjo. Mr. Atiku abandoned his governorship ambition to focus on being the vice president. His deputy Buni Haruna wanted to step in to become the governor, where INEC insisted to conduct a fresh election. Today, the justices of the Apex Court pose a question to the PDP, asking them what has changed from 1999 to 2023. Shettima, TVC News, Abuja.